The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to council as well as to all of those watching on our Supreme Court live channel. I would like to ask Mr. Doug Shima, the clerk of the appellate court, to please call the morning's 11 o'clock docket. Mr. Shima.
Thank you, Your Honor. May it please the court. 11 a.m. docket for Tuesday, December 15th, 2020 consists of one case. Appeal number 120643, State of Kansas versus Danny W. Queen, Douglas County, briefs both sides. The appellee petitioner has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Good morning, Madam Chief Justice, and may it please the court, the state of Kansas appears by Assistant District Attorney Kate Duncan Butler, present and ready for argument.
Peter Meharry, Assistant Appellate Defender, appears for Danny Queen, present and ready for argument.
Thank you, counsel. Ms. Butler, you may begin.
Thank you, and may it please the court. Again, my name is Kate Duncan Butler, representing the state of Kansas. To provide a bit of background, the state charged Danny Queen with premeditated murder and 2 counts of attempted murder after he fatally shot a man in the parking lot of a bar and attempted to shoot 2 others. At arraignment, the parties scheduled a jury trial for April 2nd, 2018. There were no continuances or changes to the trial date after that time. On the morning of trial, Queen filed a motion to dismiss in which he argued that his speedy trial time had run the previous Friday, March 30th, and he therefore had to have the case dismissed. The district court denied the motion, finding that the court's crowded docket, as well as Queen's acquiescence, allowed the trial to take place, although the speedy trial time had run. The jury later convicted Queen of second-degree murder and other charges. The Court of Appeals reversed on appeal, finding that Queen's speedy trial rights had been violated and that the exceptions cited by the district court did not apply. Today, the state is asking this court to reverse that decision and find that the exceptions cited by the district court allowed trial to take place and that Danny Queen's speedy trial rights were not violated. This appears to be a unique case in Kansas. The state is unaware of another case in which the first and only trial date was set outside the speedy trial deadline. It is undisputed that Danny Queen's speedy trial time ran on March 30th and that April 2nd was outside of that time. However, the facts leading up to the district court's decision on April 2nd, I think, are important for this court to keep in mind when considering whether the crowded docket exception, the acquiescence exception, and other exceptions apply. At the close of preliminary hearing, which was not the same date as arraignment, the court asked the parties to start considering how much trial time they needed. The state asked if they were looking at February and March for trial dates, and the district court confirmed as much. At arraignment, which was a week later, they really were only talking about March dates. The state asked the district court, please try to avoid spring break, March 19th week. It's hard to arrange witnesses during that time. At that time, the district court asked, speedy trial runs on April 30th? The state said yes. That was a mistake. The district court had miscalculated. Again, that is undisputed. At that time, the district court, the judge looking at her calendar actively, suggests April 2nd as a date. The state said it worked. The defense said that works for the defense, Your Honor. At the motions hearing, the defense reveals that at some point, and this is on April 2nd, that at some point they had become aware that April 2nd was outside the speedy trial time. They had however, not looked to the transcript, not requested the transcript from arraignment. They just filed the motion. The defense knew that there had been a mistake made by the district court and did not act.
Butler, when was the state aware of the speedy trial issue? Was it prior to April 2nd?
No, Your Honor, the state was not aware that they were outside of speedy trial until April 2nd when the motion was received that morning.
That's what I thought. I misheard you then. Okay, thank you.
You're welcome.
Counsel, doesn't our case law, I think you concede this in the brief, but doesn't our case law impose upon the prosecutor the obligation to ensure that the defendant is tried within the speedy trial dates, which by extension means when, I think it was the prosecutor was Amy McGowan, but anyway, when the court asks the question about April 30 being the speedy trial date, don't you have to concede that the state had an obligation at that moment to both know and correct the district court in the mistake that is apparent here?
Your Honor, I agree that it is the state's responsibility to bring the defendant to trial within the speedy trial deadline. And I also agree that at the time the district court misspoke, the state had an obligation to correct the district court's misstatement of fact, because at that point, the district court had made a mistake. The sort of counter to that is that it is our argument that defense counsel also had an obligation at that time to correct the district court, or at the time that the district court realized the error, or at the defense realized the error.
Why does the defense counsel have an obligation to correct a mistake like that? What obligation? Where does that stem from?
It is our argument it stems from Rule 3.3 of the Kansas Rules of Professional Conduct. That rule, the rule in the body of the rule speaks to not allowing witnesses or clients to make a mistake, or not make a mistake, make a misstatement of fact and taking remedial efforts. But the comments really dive deeper than that. And comment 2 talks about that while the lawyer has an obligation to present their client's case with persuasive force, that duty is qualified by their duty of candor to the tribunal. And it goes on to say that while the lawyer does not have to present the law impartially, they cannot allow the tribunal to be misled by false statements of law or fact. This false statement originated from the district court. And in the petition for review, we concede that if the state had said initially it's April 30th and everyone had accepted it, this argument would not have legs to stand on. But at the time,
Go ahead and finish your thought.
I apologize, Justice Lukert, but at the time, the district court was the one that made the misstatement. All counsel had the obligation as duty of candor to correct that misstatement. Neither counsel did, and it is our argument that that feeds into the acquiescence argument.
Are you suggesting that defense counsel knew that this district court's calculation was incorrect and stood silent?
The record is somewhat unclear. I know that there is a point in the initial, so the motion to dismiss was heard on April 2nd. It was later reconsidered. In the initial April 2nd motion, so Mr. Queen had 2 attorneys at district court. One of the attorneys said, I don't think I realized the district court misspoke. I cannot speak for opposing counsel. And so that's a little muddy, but it seems that they knew something had gone amiss and that it may have well stemmed from the district court.
But counsel, our case law very clearly says, and I'm quoting from the Vaughn case, and you cited that in your brief, but it says a defendant is not required to take any affirmative action to see that his or her right to a speedy trial is observed. So that being the case law, how can there possibly be a violation of some duty of candor owed by defense counsel?
Your Honor, defense counsel, their duty is separate from the defendant's obligation. And that may seem like hair splitting, but the rules of professional conduct put upon all attorneys certain duties that they have to abide by. And comments.
Counsel, I can see the point you're making if a defense counsel knows the district court is, and in fact, acquiesces or even encourages the district court in an erroneous statement. But I don't see any evidence of that here. Do you have any way? I mean, do you have any suggestion that the defense attorney knew the district court was wrong, and when asked, speedy trial runs on this date, is that right? And then basically lied to the court. I mean, that's, if you don't have evidence of that, I don't see where the defense counsel's obligation is to correct the district court.
Justice Stiegel, there's never been an allegation that there was a affirmative misstatement by defense counsel to the district court. However, we have a situation in which defense counsel at some point, and it is not clear when, but at some point before April 2nd, realized that there was a problem with speedy trial, purposely did not ask for a transcript, which suggests that they knew something was amiss and didn't want anyone to know about it.
Isn't that different from the defense counsel's duty of candor to the court? Because at that point, the defense attorney is no longer in front of the district court, and those things really, as Justice Biles suggested, those duties fall squarely on the prosecutor, not on the defense.
Justice Stiegel, I am not sure that there are many, if any, cases that talk about when the duty of candor under 3.3, when it is active and when it is not. I don't read it so narrowly as saying duty to candor is only when you're standing in the courtroom or actively talking to the judge in that moment. I think that duty of candor is also if it applies to briefs, for instance. If there is adversarial case law, an attorney in writing, although that's going to the court, has to acknowledge that. And I think many judges and many attorneys would say it's even if the briefs have been submitted, but a new case comes out that's adversarial, to let the court know, the Rule 6.09 duty. And so I think saying that because counsel discovered it at a time they weren't actively in front of the court, that duty doesn't apply when it was the court's mistake, is not what the duty of candor is meant to encompass. And of course,
it seems that if we follow your line of reasoning on that point, we are effectively overruling our line of cases that say the defendant doesn't have a duty to advise the court or to assert their right to a speedy trial. At what point does it become fall into that category of cases where the defendant doesn't have to point out to the court, oh, we have a speedy trial issue? Basically, there would never be a motion granted if a defendant had to raise the issue before the deadline expired.
Justice Lugar, I see I'm almost out of time. May I answer your question?
You may.
I respectfully, I don't think it overrules Vaughn because of the unique set of circumstances here. I am in no way arguing that anytime a defendant realizes there's a speedy trial problem, they have to alert the district court. The argument is the defense knew the district court, the court itself, had made a mistake, not that the state had made a mistake, not that wires were crossed, that the district court had made a mistake and the district court was operating on that mistake. And because it was the district court's mistake, the duty of candor, the counsel's obligation, needed to essentially override that the defendant's lack of obligation to assert their speedy trial right. And that is a very narrow, for lack of a better word, exception. It is not saying that the Vaughn language, that it's not the defendant's obligation, is not valid. It is just when the district court is the one who originates a misstatement of fact or law, this is sort of a mixed standard, that counsel is under an obligation to correct it. just as if it would if the court tried to schedule trial on Christmas because they didn't realize it was a holiday. If there are no further questions, I would reserve the rest of my time for rebuttal.
All right, thank you. Mr. Meharry?
May it please the court, Peter Meharry for Danny Queen. A couple things I'd like to, I guess, emphasize with what the state is arguing. Number one, as this court has said, the obligation falls squarely on the state. They want to continue to argue, well, it was a district court that made the mistake. Well, the state, when the district court asked when the speedy trial ran, the state said April 30th. District court, and it's in the record, said April 30th question, and the state said yes. So that's the mistake on the state's part, and it's their obligation to get it right. And as far as when defense counsel knew that this was outside speedy trial, I don't know that a specific date was ever said, but what I can point to this court is, and this is in volume 14, page 22. At that hearing, defense counsel said, we did not at the time that trial was set, realize that was outside of the speedy trial date either. So they explicitly said on the record, they did not know at arraignment that this was outside speedy trial.
Mr.
They
Meharry,
did, I'm sorry, Your Honor, go ahead.
if, and I'm looking at the transcript as well, I agree with your recitation of it. If the court had, after Ms. McGowan had said yes to the question, speedy trial would run April 30th, if the court had turned to Mr. Loomis and said, do you agree speedy trial runs April 30th, and defense counsel had said, yes, I agree, would your argument be different? Would that change in facts change the outcome here?
I think my argument probably would be different because that's a different scenario. As I said before, it's a state's obligation to bring my client to trial in a timely fashion, and my client has no obligation to say or do anything. Now, if defense counsel had said and done something to lead the court astray, I think that's a different argument. But defense counsel did not say anything.
Right, but in my hypothetical, arguably at least, a duty to candor would, in that instance, if that defense counsel later became aware of a mistake, may in fact have an obligation to affirmatively notify the court that the statement that defense counsel made in court was wrong.
He may. I don't know that I would necessarily say yes definitively, because one of the other problems I have with what the state is arguing, in this case, defense counsel realized that the trial was set out outside of the speedy trial timeframe sometime after arraignment. And the state wants to argue that defense counsel should have then went and corrected the court. What they are asking defense counsel to do is basically go against the client's best interest. Speedy trial is a complete defense, and the state is arguing to this court that knowing that they have a complete defense to these charges, defense counsel should essentially go to the court and throw it away. That, I would argue, would definitely be unethical on part of a defense counsel. They have this defense, their obligation is to their client, and they took action to that end. They didn't ask for a transcript because they didn't want to tip their hand. They were advocating for their client, and they filed a motion to dismiss because their client had a defense to these charges. They figured it out sometime after arraignment. The state never did. They apparently never went back and double checked, and it's their obligation to do so. So they can't pawn it off on the district court. They have that obligation. The district court may have started wrong, but they agreed with the district court and never figured it out. Defense counsel did, and they filed the motion as a result. So we believe that there's no duty to inform the court after the fact, to throw away this defense, because the duty is to the client first and foremost. Additionally, the crowded docket and the acquiescence arguments, mainly for the reasons the Court of Appeals said, we don't believe saves the state's case. With the crowded docket, there is simply nothing in the record that would indicate that district court could not have tried this earlier. There's nothing indicating that this was the first date. It simply threw out a date thinking it was timely. So with crowded docket, you have to have either an explicit finding or something where you can look to or point to show that there's an implicit finding that this was the first trial date available to the district court. And there just isn't anything in the arraignment to substantiate that. And additionally, other facts in the record would indicate otherwise. As defense counsel pointed out at the motion to dismiss, 5 cases that were arraigned after Danny Queen's case got trial dates before Danny Queen's case. Additionally, the district court explicitly said on the motion to dismiss hearing, if the court had known the right date for speedy trial, it would have moved things to fit things in. It could have tried this case sooner. It simply didn't realize that it had to, and neither did the state. And the state never went back and told the district court, we've got a problem, we need to move this up. Additionally, with acquiescence, we believe that the Court of Appeals was right in basically citing to this court's case, I believe it was Adams. We're simply accepting a trial date, and that's all we have here. District court said April 2nd, defense counsel said we're available. That worked for the defense. Simply passively accepting a trial date does not waive a defendant's speedy trial rights. So that does not save the case either. In short, we believe the Court of Appeals was correct in its ruling, and we would ask that this court affirm the Court of Appeals ruling, mandate that the charges against my client be dismissed.
The state had raised in its brief for the first time on an appeal an argument that the court asked if the defense wanted to file motions. The defense responded. The court then set a motion deadline and a hearing deadline. And so the state asks us to apply the 3 weeks between that deadline and the hearing, charge that against the defendant. Do you have any response to that argument?
A couple things, Your Honor. And first and foremost, the trial date was set first. So these motions did not delay the trial in any respect. So that time can't be assessed to the defendant. The speedy trial statute talks about delays that are because of the fault of the defendant. There was no delay here. Everybody agrees that the trial date was set on April 2nd. It was never moved. And that was the first date the district court threw out. So there's no delay that you can attribute to the defendant because, again, the trial was never delayed. Secondarily, we don't think the state can raise this on appeal for the first time. This was, as you mentioned, never raised before the district court. And it seems to me that it is a factual question what time would go to the state and what time would go to the defense. I would argue certainly that none of the time should go to the defense, but that does seem to be a factual question. And that is something that this court can't decide. That's something district courts decide, and this court would review. So we don't think that saves the case either. That is not something they can raise on appeal. And first and foremost, it never delayed the case. So there's no time that can be attributed to the defendant.
If we decide that, and if we disagree with your preservation problem, and we do decide that it is an issue that needs to be decided at district court and some facts, this was Chief Judge Kittle who handled this case, is that right?
Yes, Your Honor.
And she's retired, is that, we all know that. How would that occur if the judge who would be deciding this never really made the ruling in the first place? What would we do in that instance? Or do you have a suggestion?
Well, my suggestion would be that you can't figure it out at this point. It's too late in the game. The judge who presumably was looking at her calendar is no longer there. You can't get into her thought process because you're using a different judge. And this is, again, part of the problem with the state raising this for the first time on appeal. There was 2 hearings on the motion to dismiss, the original motion to dismiss and a motion to reconsider. Not once did the state bring that up. So I just don't think you can kind of Humpty Dumpty back together and figure this out. So a remand, I don't think is warranted. It's just something that is too late in the day for the state to bring up.
Mr. Meharry, let me move you to the other proffered rationale for why this trial could be effectively saved. And that is a matter that was, as I read the transcript, at least discussed and ruled on by the district court, the crowded docket exception. That's a fact finding, right?
Well, I think it's a fact finding, but I think you have to have, for the crowded docket, you have to have something in the record, not after the fact. And that's what the
what's our standard of review from your perspective on that? Are we still looking at whether evidence supports the district judge's finding of fact with deference towards the finding? How are we to review that?
I guess probably like most factual findings district courts make, this court looks for substantial competent evidence. And when you look at the record, basically the arraignment, because that's when the trial date was set. When you look at the record from the arraignment, there just isn't anything there to support that finding.
Except that the district court judge herself, as I read the transcript, again, correct me if I'm wrong, on the motion to dismiss, said, I would never have set this during spring break. Basically, she makes findings that the docket was crowded and therefore it would have been set over to the April date anyway.
I think
or
that
to the later date.
I think that finding doesn't have factual support because she did skip over spring break at the state's request. So that's a full week in March that the district court did not consider. Additionally, the following week, the week of March 26th, at the motion to, I think it's the motion to dismiss or maybe the motion for reconsideration, the district court admitted it couldn't tell whether or not that date was open. And again, there were multiple cases that came after my client's case that got trial dates before my client. So that all evidences that April 2nd wasn't chosen because that's the first date. That was chosen because the district court thought that was a timely trial. So I don't think there is evidence in the record that supports that finding, that this was the first time available for the district court.
Is it your position that a trial judge today does an arraignment and then looks at his or her calendar for the next 150 days and says, I don't have time in the next 150 days to try this week-long trial. So I am going to set this for day 153 for trial. Does that qualify under the exception? Because it is the initial setting, but it's an initial setting outside the time frame.
This wasn't necessarily an issue that was raised by either party, but the Court of Appeals certainly did kind of speculate whether or not a district court has to set a trial date within the 150 days regardless. And the statute certainly does say that they can only allow one 30-day continuance when a case is continued for a crowded docket. And the Court of Appeals thought that that indicated they had to set it within the 150 days regardless. I think if you read the statute, certainly there is an argument that the district court does have to set it within that 150 days. And I would argue that that kind of reading of the statute furthers the purpose of the statute. Certainly the speedy trial statute is to get cases tried timely, so they don't just sit and sit and sit. And a lot of times we certainly hear of courts that are busy that, they set 3-4 deep for their trial docket. But we also know 90+% of the cases plead out. So if you have three on a docket, a lot of times none of those will be tried. So if you force district courts to say, okay, well, you're number 4 on the docket, but you're within 150 days, there's not an insignificant chance that that will go and then be tried within the 150 days. So I think that reading of the statute does make sense. and it forces district courts to get cases on the docket timely to help speed up cases. So my argument, I guess, number one is I don't think that really was the ruling of the Court of Appeals, but I think they're reading the statute correctly so that this idea of moving cases forward, getting them going, forcing district courts to set them within that 150 days furthers that purpose. If there are no other questions, we would ask this court to affirm the Court of Appeals. As far as my cross petition, I would simply submit those on the cross petition and brief filed earlier.
And on those issues, do you think it's appropriate if we reach those that we would remand to the Court of Appeals for their initial consideration of those issues?
I think I thought about this, and I'm frankly not sure whether or not that's the appropriate remedy. I think this court can address them. This court has all the information the Court of Appeals did. So I think this court could address it if it wants to. I guess my argument would be somebody on appeal needs to address them. Whether or not at this court or the Court of Appeals, I don't know that I have a favorite.
Very diplomatic answer. Other questions? Ms. Butler, you reserve 3 minutes.
Thank you. May it please the court. I would like to address the crowded docket portion of the argument, which we did not really speak about in my initial argument. It is the state's position that the district court's factual findings support the crowded docket exception. The district court, a lot of what she said, the judge said when denying the motion to dismiss on crowded docket grounds, was just memorializing what happened at arraignment, but is not plain on the transcript. For instance, the fact that the court is the one looking at the calendar, the fact that the court at that time had a very busy calendar with sync docket, which later became a motions day, with her criminal docket. The judge does a very thorough job of laying out her weekly schedule, and the fact that her trial start dates were normally Wednesdays, and those were often stacked. I believe her quote is 3, 4, or sometimes 5 deep, meaning that there were up to 5 trials set to go on that date. Like Mr. Meharry said, not all those trials obviously can go, but this court was exceptionally busy. And if you look at our case law when talking about crowded docket findings sort of after the fact, it seems like the line is drawn when the district court is speculating about whether the docket was crowded versus looking at the calendar and saying, this is a crowded docket. State versus Dean, which is a Court of Appeals case, is a case in which the district court judge continued a trial. And after the fact, a different judge came and looked at that judge's calendar and said, it could not have gone on the date it was set because there was a case set that day and then a trial set the other day. That is essentially what the district court judge in this case said. At the beginning of the motion to dismiss, I think before the court had convened the case and then broke in to give the state some time to respond, but the district court said very early on, essentially, it's going to be hard for me to recreate my calendar. But based on, yes.
Sorry. Did the district court judge in this case have some kind of a conflict? And the reason I ask, it just triggers in my mind your recitation of the case you referenced where another district court judge looked at the record. Is it possible for this district court judge, knowing that she had made a mistake, I guess, on the speedy trial calculation? In other words, sort of that post hoc justification.
Your Honor, if I understand your question correctly, and please stop me if I'm totally in left field, I think it has to be this district court judge who's looking at the calendar and memorializing these facts, because that's the judge who knows this calendar and knows this judge's practices. The fact that she doesn't set cases on spring break, or I think she also says winter holiday. The fact that I see I'm out of time. May I finish my
You
answer?
may.
The fact that she knows, she's the one who knows how many cases she has stacked on her Wednesday start dates. And I think in the other case, the Dean case I cited, I get the impression from the opinion, and it's not super clear, that the second judge who looked at it, it was because that judge was the judge who was about to hear the trial on the new date, not because of a conflict. At least
How do we reconcile the judge's statement that she would have found time to try or space to try this case had she known that they were coming up against the speedy trial deadline? Doesn't that factor in that there would have been a means to try this case prior to March 30th?
Your Honor, while there would have been a means, I don't think that means that the crowded docket exception cannot apply. Dean, the case I've been talking about, speaks a little to that, where the defendant argued, well, the civil case that was part of the problem could have been rescheduled. Essentially, it's just a civil case. And the Court of Appeals said the crowded docket exception doesn't apply only to criminal cases. It doesn't suggest the court has to rearrange everything. I think the judge was grappling with a unique and complicated situation, and certainly I'm sure she could have made it happen in February if she had really wanted to by moving everything around. But I don't think that is required, and I don't think the fact that there was some ability to reorganize means it wasn't also a crowded docket.
So counsel, are you saying then that the judge has no obligation to try the most important cases first, knowing that if something falls off, that it ought to be the least important case?
Justice Wilson, I struggle to try to label cases with varying levels of importance. Obviously, a week-long murder trial is very different than, I think one of the cases that was set in that interim time period was a one-day drug possession sort of case. They are very different cases, but at the same time, there's a lot of other considerations that judges have to take into account, including, the schedules of the other judges in the district. It is very hard to have 3 major jury trials happening on the same day. So that may be a factor that plays in. The prosecutor's schedule, defense counsel's schedule, the speedy trial on other cases. And so I think judges are generally thoughtful about that, but I don't know that it goes so far as, well, the higher level felonies should come first over lower level felonies or that sort of thing. I hope that answers your question.
Does somebody have a responsibility to decide the relative importance if there's not enough time to try everything?
I think importance is a consideration of all the moving parts. I think it's one factor to be considered. And, I'm not an expert in the inner workings of how judicial districts parcel out cases, how judges set cases. That is far outside of my area of expertise. But I think although it is something that should be considered, it is not the only consideration. And I think it is just one piece of a very complicated puzzle.
Ms. Butler, jumping back to the new argument raised on appeal, the effect of the motions on speedy trial, how do you respond to Mr. Meharry's argument that that time cannot be assessed against the defendant because there is no delay here? Is that the proper argument, or what's your response to that argument?
Justice Wall, my response to that argument is there are cases indicating that a time can be assessed to the defendant even when it doesn't change the trial date. There's a unpublished Court of Appeals opinion, State versus Martinez, that is cited in our petition for review, and I think the brief as well, that sort of speaks to that. The fact is that period of time was built in for Mr. Queen to file motions. It was essentially Mr. Queen's motion time. And although it didn't change the trial date, that time belonged to the defendant because the defendant wanted that time to effectuate motions. And so our argument is basically when they're requesting that time, even if it's not changing the trial date, it should go to the defendant because it's their time.
Counsel,
And what's your response to Mr. Harry's argument that that requires some fact finding by the judge before we can apply it?
Your Honor, I'm not sure what further facts need to be found. The state's argument is fairly straightforward that because he wanted motions time and then used that motions time filing motions, then that should go to the defendant. I don't know what other facts are to be found. So respectfully, I mean, one of the exceptions cited by the state was that it's on undisputed facts, and I don't think other facts are needed.
I guess I want to give you one more shot at me. I can't get past the fact that our case law puts the obligation on the state to ensure that a defendant is provided a speedy trial. And you would agree, wouldn't you, that we wouldn't be here having these discussions if when the court asked if April 30th was the date, if the state had just said no?
I would agree with that, Your Honor. I don't think there would have been a motion to dismiss if the state had said no on that day.
And I would like to also get your response to Mr. Meharry's answer to the statutory interpretation or construction question. When we start with subsection A, that refers to sets the 150-day limitation, and then says there are exceptions where the delay happens as the result of the application or fault of the defendant, or a continuance is ordered under subsection E. And then you get to subsection E, and I know you focus in subsection E on the first sentence that uses the word extension. But then when you get down to subpart 4, the part that applies here for the crowded docket, the word continuance is used again. How do we deal with the plain, ordinary meaning of the word continuance? It's repeated twice in referencing this situation.
Your Honor, I think it does apply to continuances, certainly, but I think overall the language is quite broad and is more sweeping than that. That it is meant to be an addition of time, and the fact that there is no, in subsection 4, the crowded docket exception, there's no reference to what the procedural posture of the case must be at that time. And I also think, and so while I think continuance is an outer bound, saying you get, if there's a continuance, it is 1, here's how long it is, to prevent a court from perpetually granting continuances because, oh, I'm too busy, oh, there's too many other cases. I think it sets the outer bounds, but I don't think it prevents that exception from being used in the first instance. And I would also note that reading it as continuance only, the exception seems to indicate allowing courts some wiggle room because understanding the district court controls its own calendar, the district court knows what it has time to do and not do. And so to say, well, it's only in a continuance situation where there are plenty of district courts that the first setting by virtue of other cases may not be able to happen within that time and need that extra 30 days to make it happen in the first instance, I think it really ties the district court's hands in a way that runs counter to why you would allow the district court crowded docket time in the first place.
I'm sorry, are you saying then that continuance means any setting that happens to fall beyond 150 days, beyond arraignment, as opposed to our formal notion of a continuance being an extension of the original trial setting?
Yes, essentially, Your Honor. I'm saying that whether it's outside that time or it's a continuance itself, that there can be only one, and that it can only be 30 days.
Are there other questions? Okay, I would thank both counsel for your arguments today. The court will take this appeal under advisement. We are in recess until 1:30 this afternoon.